You want a more detailed breakdown of the dismissal of Shirley Teeter's defamation lawsuit against Project Veritas?
I'll give you a more detailed breakdown.
For those of you who don't know me, I am Viva Frei. A Montreal litigator turned YouTuber. I do these things called vlogs, VLAWGS, where we break down and analyze something that's going on in the news in terms that can be understood by lawyers and non-lawyers alike. The risk of the types of breakdowns that I do is what I call the 80-20 rule. How much detail do I go into? Do I risk boring 80% of the people by going into detail that would only be interesting to 20% of the people? Is every vlog going to be a 15-minute thorough analysis, or some of them going to be one-point punches, like let's just deal with directed verdict? If they are one-point punches, some people are going to be rightly disappointed that I didn't go into excruciating detail on all fronts of an otherwise interesting lawsuit. And yesterday I put out a one-punch analysis just breaking down how it was that Shirley Teeter's defamation lawsuit against Project Veritas and James O'Keefe, which was a trial by jury, was actually dismissed by the judge before the jury even deliberated on the merits of the dispute. The defamation lawsuit filed by one Shirley Teeter against Project Veritas and James O'Keefe was recently dismissed, and it is impossible to understand what exactly is going on unless one understands what a directed verdict is. Directed verdict. It is time to
Drop the vlog.
And that analysis focused only on what a directed verdict was, which is basically the power of a judge to dismiss a lawsuit without leaving it in the hands of the jury when there has been little to no evidence adduced of the essential element of the question at law. Okay, you want to get down here? Get down. Oh, this is Barney, by the way. Hello, Barney. So in my previous analysis, some people were commenting that I didn't go into sufficient detail as to what the Rule 50 was, which allowed the judge to come to the directed verdict. Basically, the Rule 50 is a rule of procedure that gives a judge authority to render a directed verdict, thus dismissing a lawsuit before it even goes into deliberation with the jury. Other people took issue with certain comments that I made dealing with the potential accusations of political bias by a judge, and some people were taking that to mean that I was actually implying political bias by the judge in the judgment rendered. Not at all the case, and we'll get there. Other people wanted more clarification on the criteria of actual malice and how it applies to this suit when an individual goes from being a private individual to a public figure, such that the criteria of actual malice applies to them as relates to reporting in the press. Other people just criticized me for being a Canadian and coming from a country with no freedom of speech, and we'll get to that too, so let's just get to these points one by one. As relates to the accusations of me being a Canadian lawyer and coming from a country with no freedom of speech, we do have freedom of speech. We even have freedom of the press, and it is enshrined in our Constitution at Section 2B. That being said, we definitely come from a country that has more limitations placed on the freedom of speech. We definitely live in a jurisdiction that is more pro-plaintiff than pro-defendant when it comes to defamation lawsuits. And we live in a jurisdiction that does not apply the criteria of actual malice in the context of defamation lawsuits against the press. And so for a plaintiff to succeed on a defamation claim against the press in Canada, the plaintiff need not prove the actual malice of the press as is required in the United States. And what does this mean? Even in Canada, if someone is a public figure, the threshold for succeeding on a claim of defamation against a third party or the press is higher than if the person is a private figure. And this distinction between private and public figure is essential in the American system as well, and we'll get there. In Canada, for a plaintiff to succeed on a defamation claim, if they are a private individual, the burden of proof on them in order to succeed is going to be less than that of a public figure. And in Canada, in order for someone to succeed on a claim of defamation, they need only prove that these statements were made, they were public, and they were false, and they damaged the reputation of the person against whom they were made. And if they are a public figure and the statements were made by the press, there's going to be a greater degree of latitude given to the press in terms of making public statements about these public figures. But even in the context of a public figure versus the press, in Canada, the public figure need not prove actual malice of the press in making the comments that they made publicly. Whereas in America, the freedom of the press is so deeply enshrined in the Constitution, in the First Amendment, that if the plaintiff is a public figure, they need not only prove that these statements made by the press were false, but that they were made with actual malice with the deliberate intent to harm the plaintiff. And so then, the question becomes determining when an individual goes from being a private individual to a public figure, such that they need prove the actual malice of the press. And my understanding is that under American law, jurisprudence has set out two types of public figures. You have your public figures like celebrities, rock singers, etc., and you have your limited purpose public figures, which are otherwise private individuals who become public figures on specific issues, for specific purposes. For example, standing a trial. For example, taking certain matters to the press and making appearances as relates to certain incidents. And this is where we get into the Shirley Teeter defamation lawsuit versus Project Veritas and James O'Keefe. My understanding of the situation is that Shirley Teeter alleges that she was assaulted at a Trump rally and took her story to the press, and in so doing became presumably a limited purpose public figure as relates to her story of what happened at the Trump rally, such that Project Veritas's coverage of her and the subsequent coverage they put together was legitimate press coverage of a limited purpose public figure, such that Shirley Teeter, in order to succeed on her defamation claim against Project Veritas and James O'Keefe, had to prove not only that the statements were defamatory and false, but that they were made with actual malice. And for those of you who don't know the details of what actually led up to the Shirley Teeter lawsuit against James O'Keefe and Project Veritas, there are a ton of videos detailing what happened, but in the smallest of nutshells, Shirley Teeter is an elderly woman who showed up at a Trump rally and alleges that she was assaulted. Shirley Teeter is an elderly lady from North Carolina who suffers from COPD. And apparently after she took her story to the media, Project Veritas was doing some undercover reporting, and they got undercover footage of a Democratic operative admitting to hiring an elderly lady from North Carolina who suffered from COPD to engage in what is called bird dogging, which is basically the act of showing up at a political adversary's rally in the hopes of getting into a kerfuffle so that they can then publicize that kerfuffle to paint the political opponent in a negative light. And that's pretty much exactly what happened. Shirley Teeter alleges that she was assaulted, took her story to the media, and that's how the story got put together. Shirley Teeter alleged that Project Veritas and James O'Keefe defamed her in their reporting. Their defense was that we were simply reporting the words of what this Democratic operative said undercover to one of our undercover cameras, and Shirley Teeter opted for a trial by jury, which nonetheless has a presiding judge who is the gatekeeper of evidence, rules on admissibility of evidence, rules on objections, etc. And for the purposes of the trial, Shirley Teeter was deemed to be a public figure, if only a limited purpose public figure, who had to prove actual malice in order to succeed on her defamation claim against Project Veritas and James O'Keefe. From what I understand, after 3 days, the plaintiff closed her proof, which basically means that she adduced all the evidence she was ever going to adduce in support of her claim, said, my evidence is closed, now we move on to the defendant. And the defendant brought a motion in virtue of Rule 50, which basically states that if the plaintiff has not proven the essential elements of the claim, it doesn't even need to go to a jury for adjudication. The presiding judge can dismiss the suit based on the fact that no evidence had been adduced to the essential elements that need to be proven in order to even get to a deliberation by jury. And Rule 50 is also known as a judgment as a matter of law, meaning that it is a judgment that a judge can render because it is one that is a pure issue of law. And I'll read Section 50 so we can have the benefit of knowing what it says. If a party has been fully heard on an issue during a jury trial and the court finds that a reasonable jury would not have legally sufficient evidentiary basis to find for the party on that issue, the court may resolve the issue against the party and grant a motion for judgment as a matter of law against the party on a claim or defense that, under the controlling law, can be maintained or defeated only with a favorable finding on that issue. A motion for judgment as a matter of law may be made at any time before the case is submitted to the jury. The motion must specify the judgment sought and the law and the facts that entitle the movant to the judgment. And my understanding, although I may be wrong, and if I am, please correct me, a judge can even raise a Rule 50 of their own volition, although typically it's done by motion of one of the parties. And in this case, James O'Keefe and Project Veritas' defense attorneys raised a Rule 50 dismissal on the basis that the plaintiff had not proven actual malice, such that the matter need not even be given to a jury for deliberation. And apparently there was some extensive back and forth between the judge and the parties. And after giving the plaintiff a chance to respond to the defendant's motion to dismiss under Rule 50, the judge concluded that there was absolutely no evidence that had been adduced to prove the actual malice of James O'Keefe and Project Veritas. All of the arguments raised by the plaintiff's attorneys were deemed to be spurious at best by the judge. And the judge concluded that although exceptional, it was a warranted case to apply Rule 50 and dismiss the lawsuit by way of directed verdict, because as the judge said, anything to the contrary would basically have the effect of eviscerating the First Amendment in the United States. So that is the more detailed explanation of what actually went down. And in my previous analysis, I made some comments about how this could ostensibly be seen as a partisan decision by a partisan judge appointed by George Bush, etc., etc. And this is where we can get into some serious political bias, partisan interpretation of what went down. The judge who dismissed the lawsuit before it even got to the jury was appointed by George W. Bush, presumably a conservative judge appointed by a Republican George W. Bush, dismissing a lawsuit based on a directed verdict. A lawsuit filed by someone who is protesting Trump, suing a conservative news outlet for the coverage they did of the incident. One does not have to be overly empathetic or imaginative in order to switch the roles and then imagine how they would feel. If an Obama-appointed judge dismisses by directed verdict Nicholas Sandmann's lawsuit against Washington Post, CNN, NBC Universal, you can imagine that there's going to be a fair amount of people crying foul. And in this situation, I can easily imagine how some people are going to feel that this is, don't call it corruption, but call it favoritism, call it whatever you want. They're going to interpret what went on through the political blinders through which they see the world. That's just the nature of politics these days. It's unfortunate, but everybody sees the world through their political blinders and interprets what happens through those blinders. My point in making that observation was not to affirm that or even state that. On the contrary, it was an observation about how we live in an era now where people only view things and they seek to interpret facts through their political blinders. And the risk is that people who don't actually understand the ins and outs of how this judge came to that conclusion run the risk of seeing it as some form of political bias, judicial activism from the bench, having the judge dismiss the lawsuit before the jury even gets a chance to adjudicate on it. My point was not to suggest or affirm that this is what actually happened, but rather to observe the fact that we live in a world now where people attack the intentions and not the arguments. They go after the person and not the substance of what is being presented. And I propose the hypothetical thought experiment that if the roles were entirely reversed, how people could see this through those same political blinders. If a judge dismisses Nicholas Sandmann's lawsuit on a Rule 50 without even letting a jury adjudicate on the substance of it. And again, in doing that, it was not to argue that those two situations are similar whatsoever. For those of you who have never seen my previous videos, I have already placed my legal bets on how the Nicholas Sandmann lawsuit is going to end up. My prediction, and this is just an assessment in law, if this ever goes to trial, Nick Sandmann is going to win. He's not necessarily going to win $75 million in compensatory damages and $200 million in punitive damages, but he's going to win something. And I suspect people might attack this prediction on the perceived basis of political bias, especially not having seen NBC Universal's defense. And my prediction is susceptible of change in the event that new facts come out that I was not previously aware of. But I was closely following this at the time, and I don't think that there are radically new facts of which I am unaware that might show up in NBC Universal's defense. That being said, there are also high chances that this never gets to trial and that this gets settled well before. I suspect that NBC Universal has insurance that covers these types of claims, and that one way or another this might not be the type of thing they want to bring to a jury of 12 citizens. It was not to equate the two lawsuits on any factual matter, and there is no but to that. It was only to illustrate the fact that if the roles are reversed, how people, viewing things through political blinders in an era of hyperpolitics, would move beyond the substance of the judgment and attempt to undermine the substance of the judgment based on the perceived intentions of the person rendering the judgment. And like I said in my previous video, I am a commercial litigator, and in Quebec, civil trial by juries has been abolished for like 40 years, I think. And in criminal matters, I can understand much more easily how a Rule 50 would apply. A judge is going to dismiss a lawsuit on a pure matter of law, as opposed to giving the jury the opportunity to wrongly convict a defendant in the absence of any legal basis to do so. So I was just surprised to see it in a civil matter, and this is what caused me to look into the matter a little further to see how, in fact, it occurred. And as you can see by the change in lighting here, the sun has come out, and it may be time for me to get out of this stifling shirt and get into the garden to plant some chili peppers. If you like this video, be sure to like, share, subscribe, hit the notification bell, leave a comment below. As you can see, I read the comments and I do respond as best I can, and I do appreciate that the previous video I did on the subject was a bullet point summary of one issue. It was more complex, and enough of you seem to want more details on the complexities and the ins and outs of the situation, so I did it. And I want people to appreciate that in Canada we do have freedom of speech. It just happens to be not as extensive as the system in America. For good or for bad, there's going to be people who like it, there's going to be people who don't like it. I've said this in previous videos, and I'll say it again and again and again. I am a proponent of free speech. I believe in imperfect freedom of speech as opposed to perfect censorship. How this plays out in real life is a question of degrees. We are talking about shades of gray and not black and white, not all or nothing. That is it, and now you know your vlog. Peace out. Boom!